And welcome to Be Informed. My name is Carl Buhariwala, and I founded Be Informed to help people make good decisions. Today, we are joined by Jordan Vaka of PlanningSolo, who will be talking about superannuation benefits, in particular, structuring and accessing superannuation death benefits in Australia. Before I proceed, I would like to acknowledge the traditional owners of the lands on which we're meeting today and pay my respects to their elders, past and present. Today's session is of a regulatory nature, so please do bear in mind that the topic presented today is current as of today, and any information shared is in relation to the Australian jurisdiction. So if you do have any queries beyond this date, or if you reside outside of Australia or looking from a different perspective, please do consider its applicability to you. You may wish to consult a professional to check whether your thinking is correct. In terms of housekeeping matters, if you do have any questions, please send them through the chat function to me, and then I will then relay them through to Jordan. The session is being recorded, so don't worry if you have to drop out or drop in later and if you have to miss a portion of it. Don't worry, it is being recorded and you can see it online on our YouTube channel following today's session. And also, Jordan has kindly prepared a one-page handout, which I will email to registered participants for their safekeeping, and they can use it as they wish and share it with family and friends. So with that all in mind, I will now hand over to Jordan, who will take you through the seminar, and then after that we'll jump into Q&A. Over to you, Jordan.
Thanks for that, Carl. Thanks very much for having me on. This is, I've been looking forward to this. It's going to be an interesting one. So, talking about superannuation death benefits in Australia, it's a very specific topic, and a lot of what we're about to talk about today comes from my experience in helping people through this phase of things. So a lot of my work is helping largely widows navigate the superannuation death benefit process, and there are quite a few complexities. So we'll jump into them. But firstly, Carl, we might start on the next slide where we just talk about what it actually is. And before I do, just to reiterate what Carl was saying, very much everything we're going to talk about today is general advice only. Do not take any action based on what we're talking about here. Be sure to get your own independent professional advice because you can make mistakes in this space and they can be very expensive. So make sure you get advice. But let's kick off and talk about death benefits and what they actually are. Essentially, it is the payment that comes out of your superannuation fund following the death of the member. Now, that death benefit is then made up of two different components. There's the deceased's superannuation balance, which is the accumulated balance of all of your contributions over the lifetime of the account, plus your earnings in there as well, and is then topped up by any life insurance you may have owned within the superannuation account. So keeping in mind that a superannuation fund can pay for life insurance and TPD and income protection, but we'll leave them off the table for now. It can pay for life insurance for the benefit of the member. When the member passes away, that life insurance is often paid into the member's account balance. It can be paid out to other beneficiaries, but that's a different kettle of fish, and I think I'm already touching on what makes this area so complex. But in this instance, the money lands in the member's account balance and is then paid out. So the trustee of the superannuation fund, they make all the decisions on behalf of the members. So when they've been notified the member has passed away, they'll make their assessment, and then they will pay out the death benefit. Now that death benefit, the combined total of the balance and the life insurance, can be paid out in one of three ways. The first one is a flat lump sum payment. Now that lump sum payment can go out to the LPR, or the legal personal representative, a proxy for the executor of the person's estate. It can be paid out to an individual, often a spouse or a child, or it can be paid out to a series of people so long as the nomination meets 100%. So it could be paid out 50% to a spouse, 25% to each of the two kids. So that will be paid out as a lump sum. The account is liquidated. Any shares or investments within the fund are sold. They're paid out. Another option is to have it paid out as a reversionary pension. Now, what this means is that in the instance where that superannuation account has gone from that accumulation stage, so you're still working, you're still pumping money in, you've gone from that and you've tipped it over into decumulation or pension phase. At that stage, you're starting to draw out a regular income, normally monthly, to live on. In that instance, if the member dies while in pension phase, it can, if it's been properly set up initially, be paid out as a reversionary pension, which means that pension transfers to the nominated beneficiary. It has to be their spouse in all likelihood. So it goes from the payments to, Ms. Jill Smith. Mrs. Jill Smith is getting paid $3,000 a month from her account-based pension with her super fund. Mrs. Smith passes away, but she's nominated for Mr. John Smith to receive her pension as a reversionary account. The following month, after it's all resolved, $3,000 gets paid to Mr. Smith for the continuation of that balance until it's exhausted. There's some pretty handy tax benefits in doing so. Tax is a big factor when it comes to working on these considerations, and we will come back to that and talk about that in a bit more detail. So it's option number 2 is a reversionary pension. Not every super fund offers a reversionary pension. If it's something that you are interested in, you should be talking to your super fund or your advisor around how you can have that set up if that's something you're looking to do. The third option is even rarer than the reversionary pension, and this is a child pension. And what this is that in the event that a member passes away and has children, they can leave their death benefit to be paid to their children as a child pension. Again, there are some really significant tax benefits in setting it up like this, but it brings quite a bit of complexity into the equation, which is why not every super fund offers it. Excuse me. With the child pension, with those tax benefits, what it can do is it can get you away from minor tax rates, which is another topic in and of itself. But essentially, minor children or kids under the age of 18 have a level of taxation that's quite punitive to discourage parents and people dividing their income amongst their children to minimize their overall tax. So if a child is earning an income above $416 that isn't sort of earned from employment, they'll be taxed at 66%, which is a really high tax rate. Having a child pension set up instead can get you kind of minimize the impact of that, if not avoid it completely. So it's a very, very handy benefit. And I've sort of joked about it, but this is a fairly complex area. And we will talk about where this plugs into your overall estate plan in a few slides as well. But just to reiterate, the superannuation death benefit is what it sounds like. It is the payment out of a superannuation member's account upon their death. It includes their accumulated balance and life insurance payout as well. There is an important distinction between those components, which we'll come to in a second, also about tax. And we're going to really dig into the complexities around tax. And then the death benefit can be paid in one of 3 ways: a lump sum, a reversionary pension, or a child pension. Carl, we might hop across to the next slide as well, if we could, please. Thank you. And this is where things get a bit more complicated, because the next question that's reasonable to ask is, of the death benefits, to whom can they then be paid? Can they be paid to anybody? Could you have it paid out to the milk bar owner across the street? The short answer is probably not. It depends, though, is more accurately the case, because there's 2 different sets of laws that interact here to define, firstly, who can it be paid to? And then when it is paid to them, what tax are they going to pay? So the first consideration is the superannuation law, which is commonly called the SIS Act, or the Superannuation Industry Supervision Act. This covers all of the rules around superannuation, how it should be managed, what it's for, all of these things. Now, in those laws, there is a very specific schedule that outlines who money can be paid to out of a superannuation account. And as you can see in the table here, it all hinges on whether or not that person is considered to be a dependent. That idea of dependency is a really powerful one when it comes to this kind of analysis, because ultimately the money that gets paid out needs to ultimately finish with somebody who is a dependent on the deceased. The thing is, though, of course, superannuation and tax law have different definitions of dependent. So you'll see here that under super laws, spouse is considered a financial dependent, but a former spouse is not. So it can sometimes be a little bit tricky to define, the formerness of that spousal relationship. But if it's cut and dried, divorce has been finalised, it happened 10 years ago, you're no longer a spouse, then you can't really prove a dependency relationship under the superannuation law. A minor child, so a child under the age of 18, is a superannuation dependent. Under superannuation laws, though, which does differ, kids over the age of 18 are also considered a dependent. So remember that this column is all about, can the money go to this person? Not in what format, not how will it be taxed, simply can the trustee take the money from the deceased member's account and give it to this person or this person? So 18-year, senior or non-minor child, so an 18-year-old plus child, is considered a superannuation dependent. An interdependency relationship can be very, very hard to prove, but if you can prove it, then yes, they will be considered a dependent. Now, what is an interdependency relationship? It is a relationship that can be shown to demonstrate a dependency amongst the two parties. So a common one could be, the one you see the most is sort of a widower or a widow living in a house with a niece or a nephew. The niece or the nephew is sort of late teens, early 20s, mid 20s, but maybe they're studying, or maybe they have some reason they're not able to work. Perhaps they have health issues that prevent them from joining the workforce. So there is a history then of the senior person providing monetary support to the junior person, but in return, the junior person is providing support to the senior person of another matter. It might be they're providing ongoing medical care, household care, something like that. But it can be shown over time, and there is documentary requirements around this because it is a pretty important trigger. If it can be shown that they were both dependent on each other, then the junior person would be able to make a claim or expect a payment, receive a payment from the super fund. Now, interdependency is very, very difficult to prove. I haven't seen too many of them in my career, but they are relationships that exist, and it is worth being aware of that if you are making this as a nomination, you need to be very clear on your basis for that. An ordinary meaning dependent is kind of a bit more of a catch-all. Just was that person entirely dependent on them? I'm not too familiar with some cases around this, but I imagine it's things like non-adopted children being left with their non-birth parent, perhaps. So something like that you could expect them to be dependent, but physically and legally speaking, they don't meet the requirement of a minor child. They haven't been legally adopted. It's been a bit of a de facto arrangement. You could argue that they're an ordinary meaning dependent. Now, is there anybody else that can be paid? And the simple answer is no. The superannuation laws are exclusive. They just nominate exactly who can be paid, and they don't have that other category. So that's the list of people to whom the super benefit can be paid. It's pretty comprehensive. Then on the taxation side of it, which is simply through the Income Tax Assessment Act, they nominate exactly how much they'll be taxed. So people can still receive the money, but there will be different tax consequences for different groups. So under taxation laws, spouses, minor children, well, we'll come to the tax in a sec. This is also just saying who can it be paid to. So the primary points of distinction there are under the tax rules, you can't really pay money to a child over the age of 18. That's not a category that's included, but you do have that other category. So if you can then look to develop a different version of dependent that would satisfy the requirement, you might be able to get the payment through. But generally speaking, for somebody like me, if somebody has adult children, we would be very, very reluctant to have a client nominate that the money be paid through to their adult dependent or their adult child. And the other consideration there is that when you are making a nomination, again, we'll come to what that means in more detail shortly. When you're making that nomination, the trustee will have final discretion as to whether or not they accept it. So they may also just not accept your nomination form. So then the main differences between the superannuation and the taxation laws as to whom the money can be paid to. Carl, the next slide should go through the actual tax impact. So let's assume that the money, we've defined that it can be paid out. And it's going to be paid out to somebody who is either a dependent under the super laws. The next question then is this person also a dependent under the tax laws, which is that former table we've outlined who that is, more or less anybody except for kids over the age of 18. Or a former spouse. Now, the reason this is really important is that distinction between tax dependent or non-tax dependent will define how that person is taxed. So if, for instance, Mrs. Jones has $1 million in a super account and she passes away, and let's assume that it's all taxable taxed. That money going to Mr. Jones, given that he is her spouse and therefore a tax dependent, will not be taxed at all. It's considered non-assessable, non-exempt income. The money will just pass through to her surviving spouse. Now, if on the other hand, Mrs. Jones wanted to leave that money to Jack Jones, her 22-year-old son, that money, because he is not a tax dependent, that money would be taxed in his hands at 15%, so $150,000 in this example, plus the Medicare levy of 2%. Now, it is important to point out that you can avoid the Medicare levy with some clever structuring through your estate planning documents, but there are pros and cons there that should be considered with a specialist estate planning solicitor. But just to recap, for the taxable taxed element, the money going to a spouse is tax-free. The money going to a non-tax dependent, like an adult child, is taxed at 15% plus 2% Medicare levy. Now, you will see here that we've got three different components within the super fund. So we can take a step back outside of the death benefit payment bit. Everybody's super fund has these three components. In the internal holdings of the superannuation fund will have three components. These are the tax components. There is another set of components, this is why I have a job, because superannuation is so confusing. You have another thing called preservation components, which dictates whether or not you can access that money yet. And that's where you start talking about things like conditions of release, ages, retirement, things like that. We're not talking about that today. We're simply talking about taxation components. So when we're saying taxation components, the three components are taxable taxed, taxable untaxed, and tax-free. So there's different ways that money gets into super, but broadly speaking, if you have claimed a tax deduction on one end of the equation, you will have a tax payment on the other end of the equation. If you haven't claimed a tax deduction, you've used after-tax money on one end, you should get the benefits tax-free at the other end. So a taxable tax component is commonly made up of your work contributions, so your superannuation guarantee contributions, salary sacrifice contributions, or other what's called concessional contributions into your super fund. So you claim a tax deduction or you reduce your income in some manner, the money goes into your super fund, you pay 15% on the way into the super fund, but it's then taxed later on as well. It's taxed because you made the tax deduction claim personally, it's taxed at the other end if it goes to a non-tax dependent. A taxable untaxed component is very uncommon. Primarily, you see this come out of public service funds. So the big one is, I forget the name of it. There's a big public service one in Canberra, Commonwealth Super Services, I think. So they have a defined benefit option, which is very different to your standard super fund. A quick note on defined benefit is it's normally a multiple of your final average salary in your final years of retirement equals a lump sum, and that's your super balance. So it's very different to where it is now, where you put the money into super and it grows thanks to investments, or may not. You're carrying all the risk. Defined benefit, all the risk is being carried by the provider. That benefit, when you pass away, is very commonly an untaxed amount. Now, the reason that's relevant, and there is the other component that's often untaxed, is life insurance. TPD insurance can be as well. So the reason that's relevant is that you've got this extra component that will get paid out to people. And if it goes out to a non-tax dependent, again, adult children primarily, they will pay 30% tax on that plus the Medicare levy. So it gets pretty complicated, but you've got $1 million benefit in Mrs. Jones's account. She wants and 50% of that is taxable untaxed. So $500,000 of that is taxable untaxed. She passes away. She doesn't want the money to go to Mr. John Smith. I'm getting confused with the names. She doesn't want it to go to her husband. She wants it to go to her adult son. The adult son will pay 32% tax on that $500,000. So you can see how that starts to add up pretty quickly, because then on the other $500,000, he'll be paying 15% plus 2% tax. So it adds up really quickly. If you do leave your superannuation benefit to a non-tax dependent, it has quite a big impact. And this is why it needs to be carefully considered as part of your estate plan. Now, the final component is the tax-free component, and most often that is simply from after-tax contributions that have gone into super, non-concessional contributions. Some of you may be familiar with the $110,000 non-contributions cap, non-concessional contributions cap, or the 330 bring it forward, put it all in together. That tends to form the tax-free portion. So when that's paid out, it's simply tax-free to everybody. Another question around this is, how are those components established? And can you just withdraw money from the different components in isolation? Because you've constructed these from over your contributions over time, the percentages and the proportions change. So what will happen is, if your superannuation is entirely based off your work contributions, you will be likely 100% taxable taxed component. Now, if in 10 years' time you drop in a big chunk of after-tax money, so non-concessional contributions, you will skew and change those percentages accordingly. So it's always prorated. If when you then pass away, or if you go to withdraw money out of super, the tax components, you cannot pick which one you want to use. It has to come out prorated. So if, for instance, you've got 50% taxable taxed, 30% taxable untaxed, 20% tax-free, and you want to take out $100,000, it'll be in the same ratio. You can't say, I just want to take it out of the tax-free portion. It needs to be the same ratio. Now, there are some strategies that advisors will use to change this, because a lot of people don't want their beneficiaries to necessarily pay 30% tax or 15% tax. It's becoming increasingly common for people to have adult children, so they've had children later in life. So that means that they have a higher super balance. Kids are older. It's creating this almost perfect storm of scenarios where people could be paid out large lump sums. The common strategy is called a recontribution strategy. I won't go into the mechanics of that today, but I will raise some of the concerns that us advisors have around that. Is clients that we talk to, if they're the member, they don't benefit from that strategy, only the beneficiaries do. So it's very careful if you're a client considering that strategy, just to play out the pros and cons of that and to whom that benefit will accrue, because it's quite a big consideration. Carl, we might hop across to the next one, please, as well. Thank you. So another question is, how does the super fund know where I want my money to go? And the simple answer is that it's done through a nomination process. And the nomination process contains 3 different options. You've got the binding nomination, a binding death benefit nomination, or a BDBN. Now, this is a very powerful document. It's done through a piece of paperwork that you sign. You put in your details, you nominate to whom you'd like the money to go, you sign it, and it also has to, your signature needs to be witnessed by 2 non-beneficiary adults. So you can't have your spouse witness your beneficiary nomination. No witness signatures make it non-binding. So it's a very important document. It's very hard to make sure you get it right. But if you can, normally people will sign it in front of work colleagues or family, just to make sure that it's done. But it cannot be anybody who stands to receive a benefit from the payment. So you sign that, you send it in. Superannuation trustee will assess it. If it passes muster, they'll say, great, you've now made a binding death benefit nomination, and that will either be lapsing, which means that it needs to be renewed every 3 years, or it lapses, or in some instances non-lapsing. There's some people that have done some creative legal stuff to make it so they don't lapse. Both have their pros and cons, both have risks that you should be aware of. The other option is to put in a non-binding nomination into the super fund, because then you can say, well, I mean, I don't really know why you would do it, truth be told, but a non-binding nomination is it doesn't have to be witnessed. You send in a request to the super fund and you say, upon my death, I kind of want the benefit to go to this person. Now, the binding nomination is much more explicit. It's, I nominate this person to receive this percentage of my superannuation benefit. Now, the reason there's a distinction here is the superannuation trustee. The reason there's a distinction is how much discretion do you want to leave to the superannuation trustee? So a binding nomination binds the trustee to pay out the amount in line with your wishes. So they can't say, oh, I actually don't think that Mr. Smith should get the full payment. I think, Jack Jones, the son, should get some amount of that payment. So we'll divvy it up and pay it how we think is right. A binding one is no superannuation trustee. You've already assessed this is legitimate. Just pay it out. A non-binding one is the trustee has final discretion. So they can be creative, they can consider other people's needs, other beneficiaries or potential beneficiaries that have been denied a payment, they can make a claim. It can get very messy. And like I say, I don't really know why you'd want a non-binding one. I think sometimes they come about from binding ones that have lapsed, perhaps. But otherwise, there's very little benefit to them, in my opinion. The other one that's probably the most common one, unfortunately, is to just not have a nomination at all. Often, if you've picked up your super fund through your employer or through an early job, the money will just be sitting there, and then it'll just be paid out according to some way that the trustee can work out that actually makes sense. So it's going to be that leaves a lot of administrative headaches for your family or for the people that you leave behind. So if anything out of this call, I would encourage you to consider who you want to nominate your funds to and use a binding, ideally non-lapsing nomination to make sure that's carried out in the event of your death. Another consideration is the trustee process. And this is one of the factors that we take into account when we're choosing super funds for people. If you Google ABC superannuation, so ABC News superannuation, or ABC News, and I think it's CBUS, they've been talking a lot about. Where this boils down to is, does the trustee have a really clearly defined process for paying out death benefits? Now, you would think that the answer would be yes to every super fund, but the simple answer is it's very, very different per fund. Some funds are adequately resourced with adequately experienced people that have the empathy to navigate this process really smoothly. Others have an outsourced admin process with a third-party administrator who couldn't really care. And another one is they're just too small. They don't have the resources. They've got a bit of a jack of all trades doing the job, and it just falls through the gaps. So that can be really uncomfortable and messy. And one of the reasons I quote the ABC cases is they've had somebody, I think, who was waiting a year or 2 years for a death benefit payment. Forms got lost, signatures weren't accepted. It was just a whole mess at a really insensitive time. Another consideration that we would play into our calculations is how often does the trustee meet? So all death benefit payments need to be signed off by the superannuation fund trustee. In the Act, though, there is no requirement for how frequently a super fund trustee has to meet. So if you have a self-managed super fund, you can meet once a year. The bigger funds could also, if they wanted to, meet once a year. Now imagine being in a fund that had an annual meeting and their meeting's on the 1st of June every year, and you passed away on the 2nd of June. That's then a year for that super fund to actually look at your survivor's application for payout. A more frequent occurrence is a quarterly review, a quarterly meeting of trustees. So they'll sit down, they'll have a pile of death benefits that they need to go through and review, and they will just slowly work their way through it. They may or may not get to your one in that quarterly meeting, in which case it'll roll over to the next one. So you could have a situation where somebody's put in a claim and they've had to wait 6 months before the payment's paid out. Now, in and of itself, that's not disastrous, but that 6 months can be really difficult. It can be really expensive, and it can have some really big financial implications. So some other more modern trustees, so some of the retail companies we use, they meet daily, or some meet weekly, some meet monthly. So it gives a lot more fluidity to the process, and they tend to be the ones that have put a lot more thought into how to have a caring process for people at a tough time. So think a lot about the superannuation trustee and the way that they work as well. We'll move to the next one, please, Carl. Thank you. Now, we are coming to the end of the presentation, but I did want to leave with a final note just to make it obvious to people, because it may not be very widely known. Superannuation is not an estate asset, by which I mean your will not allow for nominations or directions around your superannuation. It is kept very separate. So you can have your binding death benefit nomination pay your superannuation into your estate, so into your legal personal representative, and then have it distributed according to the wishes of the will or the terms of the will. But you need to nominate that. It doesn't default into that. So this can present some opportunities when you're dealing with a specialist estate planner or an expert estate planning solicitor. They can help to rebalance your estate using your superannuation. They can have it streamed to different places. They can use different child or reversionary pensions. There's some really cool stuff that people can do, particularly if they're working with your advisor. They can coordinate things. But you should know that it is not part of your estate automatically. So what that can mean for some people, say I don't know, you live in a house, the house has a mortgage of about 90% of its value, good income, but you don't have any other assets, but you've got $600,000-700,000 in super. If your nominations and your will and estate plan don't align, there is a possibility where perhaps one of your survivors gets left with the 10% in the family home, which they can't ever realize without selling the house, and the other survivor gets the full superannuation benefit of 600-700K, plus an insurance benefit on top of that, can lead to an imbalance. Which is why I make the point here that while it is not an estate asset, to the point where there is some debate in legal circles as to whether or not an estate could use superannuation to clear the debts of the deceased. It is not an estate asset. However, it should be part of your overall estate plan. So I'm not just talking about your will, I'm talking about powers of attorney. There should be arrangements made for that. Your whole estate plan should be a very well documented process. Superannuation should be a part of that. Commonly, that's going to require some overlap with the work of a financial advisor. So it is important then that you've got your advisors aligned in that space. I think we have a little bit of time. So we'll talk very, very briefly about self-managed super funds. The self-managed super funds are the flavor of the month again. Self-managed super fund is essentially a super fund that you are the trustee of. So you'll have a corporate trustee or a personal trustee. You are then responsible for administering this superannuation fund on behalf of the members, which is commonly you and members of your family. They can be a wonderful structure. They can be a nightmare structure. And one of the places where they can be a nightmare is upon death. Upon death, one of the rules within the superannuation rules are that the money needs to be paid out as soon as is practicable. Not practical, practicable. What that means is that assets need to be realised. So if you have a self-managed super fund that has maybe a property and a cash account, that causes real problems for when the person passes away. How do they realise the equity in that house? How, without selling the house? So it raises a lot of questions. Another issue is what happens if somebody becomes incapacitated or unable to make decisions due to sort of mental deterioration or things like that, or capacity, cognitive deterioration. That has an impact for decisions made within the super fund. Because if you are in that situation, your power of attorney does not apply to company documents. It doesn't always apply to superannuation decisions. So it gets a bit messy. This is one of those spaces where the big industry or retail funds, the administration provided by them will be a lot easier than administering your death benefit through a self-managed super fund. It's not to say it's impossible. It's not to say that it shouldn't be considered. But when you are thinking about the decision to set up a self-managed super fund or not, take into consideration how difficult will this be to get money released upon my death, or even to that point, disablement. It's a very, very complex area, and it does require, in my opinion, a lot of specialist advice to make sure it's taken care of. Carl, I think we're close to the end. That's definitely move on to the next slide if we can, but I think we're close to the end there.
Oh, yeah, we're at the end. So thank you, Jordan, for that presentation. It was very in-depth, extremely thorough. So if you do have any questions that you would like to ask him, you can ask them now if you're online, but if you're offline and watching this at a later stage, feel free to contact him directly so that you can get the support you need. Just as a reminder, this session is being recorded. So if you have joined late or need to step out a bit early, don't worry, it'll be available on our YouTube channel following today's session for your viewing at your leisure. Jordan's also provided a one-page handout, which I'll share with registered participants, so you've got that document handy with you as you navigate through the wonderful world of superannuation and associated death benefits.
It's quite a party topic, yeah. Superannuation, death, and tax.
Yeah, and it's back in the day, I used to work in a risk advisory role, sort of advising the superannuation funds on their, I guess, prudential and regulatory compliance. So it definitely is a whole different beast of its own in terms of the policy objective behind it and why it exists in the first place, coming out of the reforms in the 90s. So definitely a good thing to have in our society. But if you navigate it well, you can definitely take advantage of the benefits in the right way. And it's timely we say that because today is the day the Australian government is handing down its budget. So I don't think, and Jordan, correct me if I'm wrong, but I don't think there's anything that relevant to what we've discussed today. I hope not.
I hope they don't change anything.
But as I think as Jordan flagged, this is definitely an area that does require professional support, and also on a tax perspective, you should engage with the tax agent as well. So if you do have any further queries and want to seek more personal advice, then please do contact them directly, because today's seminar is just general only, and we're not getting to any specific personal details. So with that all in mind, let's jump into Q&A, and we'll start off. Jordan, you've actually covered off most of the questions that have been asked through the email, so that was pretty good. And some of the questions that we've got on the screen, so I'll just go through them sequentially, and then if you can just answer those, that'll be great. So the first one that we've got is just around, you mentioned the life insurance component that forms part of the benefit. Can you just remind I think some get confused with the TPD and income protection. Do all funds offer life insurance as an option through the fund, or what happens if they hold the policy separately through just a bespoke provider or a provider that issues life insurance? How does that sort of intersect with the superannuation fund and the balance that they hold?
Yeah, so there are a few complexities there. I mean, not every life insurer and not every fund will offer life insurance, TPD, or income protection. And super funds are bound by the rules to consider an insurance strategy for their members, but they don't need to offer the actual insurance itself. Life, TPD, and income protection, they're very different beasts. Life insurance pays out upon death. TPD pays out upon total permanent disability. That's a very complex topic. Income protection is the same. So if you hold the superannuation, if your fund does offer it and you hold it through there, the payout process should be a bit smoother. It's just paid out to your member account and then it's paid out to you, to your estate or to who you've nominated. If, however, you own your insurance with insurer A, but it's being paid perhaps by a superannuation rollover from superannuation B every year, in that case, you will have nominated where you want the money to go as part of the application process to insurer A, and the money will be paid out along with your wishes. It will not hit necessarily your superannuation B member account. So in that case, there'll be two different entities you're working with, two different payments made, two different structures used. In my experience, that structure is normally smoother, a little bit more administratively easy to manage. Often having another insurer within a super fund can add a bit of complexity. But yeah, so not every super fund has to offer it. If they do, it's paid out internally to your member account, but you can also hold insurance separately, and it tends to lead to a smoother experience.
Yeah, yeah, perfect. And just to summarize, that life insurance payout upon death, is that taxed in any way, or whatever the I guess the future value is, or the agreed value, that's just paid out as per that amount, right? It's not sort of reduced in any way from any cost or expense.
It falls out. It falls under the tax dependence table that we had earlier on. So it's if the ultimate beneficiary is a tax dependent, then there shouldn't be any tax payable. And I say ultimate because that applies if it goes through the will. But if the ultimate beneficiary is not a tax dependent, then there may very well be tax payable. And then a question for people with their super fund is, how is that tax? Is it withheld by the super fund and paid to the ATO, or is the beneficiary supposed to put the money aside and they'll get a tax bill later on?
Yeah, yeah. So definitely a complex area. It was just thinking through that. I think there's a few things that you have to consider, sort of maximize your I guess strategy.
And the more I do this, the more I realize there's never a silver bullet. Like every benefit has a downside. Like every downside has a benefit. You've got to work out what's best for your circumstances. There's no real kind of rule of thumb for everyone.
Well, that's right. And I think if I just remind the audience, I think this was all developed, there's a lot of policy behind this to take money out of, the age pension system and to keep people, I guess, more responsible of their future income post-retirement. But then when you do pass away, I think over time the government has latched onto, I guess, I want to say loopholes, but I think this the more creative ways of exploring the framework and the regime. So I think it's whatever suits you best. And I think, as you say, Jordan, you're right. There's no two people are alike, right? We're all different. We all have different motivations and needs and families, etc.
Yep.
Therefore, you need to really choose one that suits you, not just adopt or apply someone else's approach, because it may not be as relevant to what you want to achieve.
Absolutely.
And we just had a question. So, on the first slide, you talked about how the benefits can be paid out, so lump sum and reversionary and child, and of course, lump sum is probably the most used, I guess. Is there any way for those wishing to, I guess, instead of taking a lump sum, keep it in the superannuation fund so that they can then earn the returns over time and just take it as an annuity? Is there anything like that that's available, or do you just have to take it in one fell swoop? And
you have to put it out. Yeah, it's a bit of a trap actually. A few people have been caught by that because it's not often. Sometimes it's not to your benefit to take it out of super. To your point, you want to keep it in there if you can. If you don't need the money, it's a good place for it to be. But under the rules for a lump sum, it has to be paid out as soon as is practicable, and it has to actually hit your account or be removed from the super fund. You can then choose to put it back in if you're able to, but the only way we can keep it in the superannuation environment is via one of those pension options.
Yeah, definitely. That's right. Okay, and we've got two more questions because you've very comprehensively covered off all the other ones.
It's a nice way of saying I spoke very quickly, but thank you.
No. I think it was I think this is an area that does, I hope, deserve a bit more attention than probably what it does receive. I think the general consensus of superannuation is just in a set and forget type arrangement. And actually, this what I'm about to say leads on to my next question, right, which is around nominations, right? And as you said, a lot of people just don't do anything about it. What active steps can they take? I don't know what the answer is going to be, but I think just to remind them, and this is the question that we've got, is what active steps can they take to remind their family members of ensuring that they've actually nominated someone? Is it as simple as just contacting the super fund, getting the necessary forms, doing the necessary process, I guess, and filing them for that 3-year period? Would that be a correct
Yes,
information?
spot on. Everybody's superannuation statement will be coming out a few months from now. And on that, they will say, have you nominated a beneficiary? And they'll have the name of the beneficiary and the nature of the nomination, if it's binding or non-binding. Just have a look at that and see if that aligns with your wishes and it is binding, you can probably let it slide. If it doesn't, though, call your super fund and say, I'd like to arrange a binding death benefit nomination form. Can you post it out to me or can I print it off? And then go through the steps. And it is kind of onerous. Like, this is one of the forms that we have a bit of trouble getting back from people because it can be hard to find 2 witnesses. People don't want to talk about money or death with their friends, but go through the effort. It'll make. I had an estate planning lawyer once explain it to me that this kind of thing is the last act of love you can give to the people you leave behind, because it is a nightmarish time to have to do all this, to do that. Another sort of former observation to that, though, is if you may not know where all of your super is. You can go through MyGov. Everybody should have a MyGov account and go through the superannuation part of the ATO website, and it'll have a list there of all super funds that they're aware of that you have. So it might be worth getting that review to see if it's still suitable to have them all separately. Don't just consolidate without getting advice, but then call each one of them and get a different binding death benefit nomination form from each of them.
I think it's very true. Even in sort of other experience that I've got, I think this is a space that's overlooked, maybe because of the emotional, I guess, tension that arises from discussing it, or having to share sometimes personal information with your witnesses, etc. But you can always get independent witnesses, like going to the police station or a pharmacy, right? Like, where they're completely independent. And but I think this is definitely a space that does need a bit more attention, because I think probably you would see it too, John. A lot of people don't care too much about this until it really matters, and then they realize it's too late and they haven't done the right diligence.
Well, I mean, not to jump in too much, but a power of attorney. So if somebody's operating under a power of attorney, they can't change the beneficiary nomination of a super fund. You cannot sign a new beneficiary form under a POA. So that can make it really complicated if maybe your parents have reached that point where they're not cognitively capable. It's a huge spanner in the works. So just make sure you've got everything lined up while you're still healthy to make sure that it works.
Yeah, right. Okay, that's interesting. Yeah. So I think, this the whole topic of estate planning, whether it be wills and POAs and death benefits, etc., under superannuation, all needs to be considered, because it's not a linear path. There are various ebbs and flows that you need to take to make sure that you don't get. I guess you don't sort of shoot yourself in the foot by not being too proactive and diligent with your process. And the final question we've got, Jordan, is just around estate planning, and you touched on the fact that you should look into that a bit more and make sure that you've covered off on all aspects. Jordan, do you personally sort of support in this space? Is that something that you advise on?
So it's not something I can help with the drafting or the structuring. That's where you need a solicitor, an estate planning solicitor. Keep an eye out for, with estates, there's estate planning, there's estate administration after they've died, or estate litigation. You want an estate planning specialist. They can help you structure. They'll ask you the series of questions that really captures it. Then they'll write up a bespoke document. Do not use a post office will. It's not cheap, but go and see a lawyer. It's an investment that'll be well worthwhile.
Yeah, so I think just to summarize that intersection between what the will says, how you've, I guess, structured your estate in general, plus what's being nominated or directed out of a superannuation fund, all sort of needs to be looked at in totality.
Spot on. They're 2 pieces of the same puzzle.
Yeah, rather than in isolation. That's right. And then if you do have any overlays with power of attorneys and other sort of legal instruments that can be used to make decisions on behalf of another, thinking about scope and how they apply in the relevant circumstances. But that brings us, I think,
absolutely.
Yeah, that brings us to the end, Jordan, and I'll just share his details on the screen again. So Jordan's off PlanningSolo. If you do have any questions, please reach out to him directly and engage with him through those channels there. And that brings us really to the end of formalities. Appreciate those that have attended today to take the time to hear about today's seminar. You can follow us on our social media pages there and check out all past episodes on YouTube. The session is being recorded, so it will be made available on our YouTube channel, and I'll be sharing the one-page handout through to registered participants. And our next session, I think, is in June and early June, and we'll be talking about sort of electric vehicles and the pros and cons of that. So if you're interested in that topic, then please join, because there's definitely an increased uptake of EVs over the past few years, but it's not always, there are some quirks that you should be aware of, especially if you are considering acquiring one or maintaining one. So I'll leave it with that. Thank you again, Jordan, for your time.
Oh, thanks for having me, Carl. Yeah, thanks very much for the opportunity.
No worries. And appreciate everyone attending. So bye for now.